Court does call the case of the people of the state of Michigan versus Linda Donald. And so state your appearances.
David, I bring on behalf of the defendant. All right.
Okay. Okay.
Welcome to one of the most charged court cases you'll ever witness. This is the People v. Linda D. And at the center of it all is a single question. Did a mental health worker cross the line when she slapped a 10-year-old autistic child during a violent meltdown? From the very first seconds, you can feel the tension. The prosecution says this is a clear case of assault on a vulnerable child. The defense insists it was a justified response in the middle of chaos. And presiding over it all is Judge Simpson, whose sharp interjections and relentless questioning will keep both attorneys on their toes. Stay with me, because the drama only escalates. We're talking about witnesses describing violent outbursts, legal wrangling over intent, and a judge who seems genuinely torn between technical law and raw human context. Who's right here? The worker trying to restrain chaos, or the prosecutors seeking accountability? You'll decide.
All right. Date time set for trial? Well, date. Almost time. You ready to proceed?
People are ready to proceed. We have sequestered our witnesses. I move sequestration of any possible defense witnesses as well.
We only anticipate one, Your Honor, and this is the defendant.
All right. Very good. Opening statement.
Your Honor, with the consent of defense, people will waive opening.
No problem.
All right. Would you like to give an opening, waive, or reserve, Mr. Colson?
We'll reserve, Your Honor.
All right. Very good.
Or I'm sorry, we'll waive.
All right. Any additional witnesses for the people?
No, Your Honor, people rest.
Your Honor, at this time, I have a motion for
Go
a
ahead.
directed verdict of not guilty.
Yes, sir.
Even in a light taken most favorable to the people, we have two CMH workers coming to a location, called there because you have an autistic, PTSD suffering individual, fairly large, I mean, 10 years old, I acknowledge, but fairly substantial stature was, I think, Katie's words, who is out of control. He was kicking, screaming, trying to hit people. And my client used only enough force to try to control the situation. What I suspect is the crux of the charge is slap on the leg.
Here the defense lays down its core argument, proportionality. In legal terms, proportionality means the force used must match the threat faced. The attorney is painting a picture of a 10-year-old child, yes, but also one described as substantial in stature and dangerously out of control. He stresses that the slap on the leg wasn't abuse, it was a reactive, instinctive move to stop a kick. Notice how he reframes the act. Not violence, but restraint. This is clever lawyering because the moment jurors or a judge hear slap, the emotional weight tilts toward aggression. By recasting it as an act of necessity, he's shifting the narrative. Viewers, think about it. If someone kicked at you during a crisis, would your reflex be to gently immobilize or to smack the limb away? That gut instinct is exactly what the defense is trying to legitimize.
And that slap on the leg came based upon the testimony of two of the witnesses of the people when my client was trying to physically calm him down and he tried to kick her. So she slaps him on the leg. That is not abuse. That's not even an assault. When she's doing that in response to an aggressive action on the part of that individual. Now, I recognize he's 10 years old, but still, everybody that testified that he was out of control and he was physically threatening. So the people have not sustained their burden of showing the charge in this case.
Response.
And I'd ask the court to deny the motion for a directed verdict and to go forward with hearing argument and making those decisions based on the proofs. And in this case, self-defense, of course, as the court knows, is a question of fact. The witnesses so far have testified that the defendant was the one who engaged in the physical contact. She was the one holding him down and that she slapped him. There is evidence to support a finding of guilt.
The prosecution wastes no time flipping the narrative. They argue it wasn't a reflex, but a deliberate choice. Their key weapon, intent. In criminal law, Assault isn't just about physical contact. It's about whether that contact was harmful, offensive, or intentional. By emphasizing that the defendant slapped rather than restrained, the prosecution is carving a legal line in the sand. They even highlight her alleged statement, "I don't care if I lose my job today," which undercuts any claim of calm professionalism. That remark screams frustration, maybe even malice. And that's exactly what prosecutors want the court to latch onto. Not a worker de-escalating, but a frustrated adult lashing out at a child. Audience question: do you buy it? Does one heated comment transform a crisis response into a crime?
In the light of the evidence viewed most favorable to the prosecution, we'd ask the court allow the trial to continue and make its decision based on the facts after hearing closing arguments, and if there is any defense testimony, of course, we ask that the court just allow the trial to continue.
Well, but would your argument be the same even if it wasn't an issue of self-defense? But if one is looking at what one has to determine the defendant's intent, and would that look at most favorably to the people in an assault charge?
I'm not sure I understand the court's question, so.
If I look at all of the evidence and light most favorable to the people, is the intent element satisfied?
People believe it has been satisfied based on the defendant's actions and her statements of, "I don't care if I lose my job today, I don't care," and continuing and then going and physically slapping a child's leg when she's already engaged in trying to have physical control over it.
Judge, I don't want to jump in, directed your question to Ms. Lundy, but let me point out the fact that that was the reason why Ms. Donald was there. She was called there by the family because this kid was out of control.
Here the defense doubles down on mission. Linda Donald was called in to deal with chaos. She wasn't a random bystander or a neighbor overstepping boundaries. She was literally hired to intervene when situations escalated. The attorney makes it clear her job was control, not observation. By stressing that the aggression was directed at her, he reframes the slap as a professional maneuver, not a personal attack. This is significant because courts often weigh duty of care. If you're placed in harm's way as part of your professional obligations, your threshold for defensive force can be different. Still, the prosecutor's counterpunch is sharp. Just because someone's job is to intervene doesn't mean they get unlimited license. The case now balances on one razor-thin issue. Was that slap an extension of her duty or a step outside it?
It was her job to, along with Katie, to try to get the situation under control. And when she's holding this individual and the individual is trying to kick her, for her to slap his foot away, I mean, the court characterized it as self-defense, and I think I may have used that word, but I think more than that is that her behavior was justified, that was why she was there, to prevent him. And I say that in the context of Katie's testimony, that most of the aggression on this kid was directed at Miss Donald.
Your Honor, there's no evidence in the record at this point to support that physically restraining the child was part of the crisis team's response. That was what? Was part of what the crisis team was there to respond to do. It was not to physically restrain the child. There's no evidence in the record to support that was part of the obligation. There's no, at this point in the record, the people have presented evidence they were there to help assess the child.
Your Honor, the burden's on the people.
Yeah, I mean, this is backwards at this point. I mean, is there any, wouldn't the burden be on the people to show, given the circumstances, that somehow she acted outside of the scope of what she was supposed to do?
When I was questioning Ms. Carroll, the other witness, she indicated that she had no physical interactions with Keaton except to take one bottle away from his hands. There was no indication that she had any physical contact with him. She didn't restrain him. She didn't touch him. She didn't sit on him.
She also testified that the physical aggression was aimed at the defendant.
Not solely.
But Okay, let me just try to get this right. Is it the people's position that the crisis intervention workers would have no authority to make physical contact with Keaton?
Judge Simpson jumps in with a critical question: where exactly do we draw the line on authority? This is not a throwaway moment. It's the judge exposing the weakest link in both arguments. If Linda had no authority to physically restrain the child, then any contact could be problematic. But if restraint was allowed, then the slap has to be judged in that context. Notice the judge pressing, where do I get that from? He's demanding legal grounding, not just moral opinion. That's a huge tell for how he's processing the case. Judges don't want vague statements. They want statutes, rules, precedents. And right here the prosecutor struggles, pointing back to parental presence as justification. That's shaky ground. Viewers, ask yourself, should trained responders stand back and let family handle violent outbursts? Or is their very role to step in when family control fails?
No authority to make physical contact with Keaton?
Yes.
In this circumstance, it doesn't appear that it would be appropriate for them to make physical contact with
Where do I get that from?
the parents. The parent and grandmother were there and present and able to physically restrain. That's the argument.
Pardon?
The mother and the grandmother were there and they could physically restrain. The people's position is that it's not appropriate for a CMH worker to slap a child.
Where do I get that from, though? Where do I get that the physical restraint would not be an appropriate response from the CMH worker? Where am I supposed to get that from?
Your Honor, when Ms. Carroll was testifying, she talked about how she did not have any physical interactions.
But the fact that she did not doesn't mean that you can't. I mean, what you're arguing, first of all, Ms. Carroll and the defendant are there in different roles.
Yes.
That was very clear by her testimony.
Yes.
So someone in the defendant's role, where do I have evidence that she exceeded some authority or action?
The exceeding of authority, the assaultive conduct is not necessarily the restraint. People are alleging a slap is where it becomes a criminal action. That is the point at which it's become a criminal.
But I have an individual, by testimony of other witnesses, kicking. And then Miss Carroll's specific testimony was that she believed that Keaton was trying to kick her at the time of the slap.
And Your Honor, then we also, the court asked about intent as well, correct?
Well, yeah, but I haven't left this subject yet.
Okay.
Because what's being argued is that somehow the defendant exceeded her authority. I'm not sure where I get that from based upon what I heard. But even if, and the people aren't arguing that the defendant could not have restrained him.
Correct.
And then the only testimony, because one of the witnesses testified she could not see what Keaton was doing at the time of the slap or right before the slap on the calf.
Ms. Victoria, yes, Your Honor.
Ms. Carroll, however, specifically stated that when the slap happened, she believes that Keaton was trying to kick her, her being the defendant.
Yes, Your Honor, that is what she testified to. The people are not arguing that the defendant had zero right to physically intervene. People's argument is that the slap was set too far, and that's why we're asking the court to deny the motion for the directed verdict and allow the trial to continue to a verdict.
Here's the drama condensed. Prosecutors admit Linda could physically intervene. They concede she wasn't over the line just by restraining, but then comes their pivot. The slap is where it crosses. From crisis management to criminal action, it's a tactical distinction, but also a psychological one. A grab implies control, a slap implies punishment, and that perception shift is exactly what the prosecution wants the judge to internalize. This framing strategy is brilliant because it doesn't demonize Linda completely, it isolates one single act as unacceptable. That narrow focus keeps the argument tight and believable, but it also begs the question, is the law really so precise that a hand gripping a leg is legal, while a hand slapping a leg is criminal? The thinness of that line could decide her fate.
How does the people's theory that it's a step too far? Was she supposed, if someone was trying to kick her, Keaton, is she supposed to let that happen? Or are the people arguing that that technique, as opposed to grabbing and restraining his leg, is what makes this different?
Yes, Your Honor, the latter.
So she should have grabbed and restrained his leg rather than a slap to the leg of "don't do that."
If I was to advise action,
Okay, let's assume that, and I get what the people's argument is. Where do I get that either of those would be appropriate, or that either would be inappropriate, or where do I have anything that draws a distinction between the two?
the touching done by the defendant to restrain Keaton from hurting others or hurting himself was done in the sense of stopping that from happening. The slap is where it becomes harmful, offensive, or violent touching. The touching in a slap to the leg of the autistic child having a meltdown is very different than a restraint of him, stopping him from hurting himself or stopping him from hurting others. Her behavior after the incident, when she's speaking with Ms. Carroll about what happened, and the evidence before the court of her not wanting to discuss the incident, of her not.
I'm at a loss, Ms. Lundy. I'm at a loss to figure out if she grabbed his leg as opposed to slapping his leg, what becomes the distinction in that as to whether or not one constitutes an assault and the other does not?
This is the turning point. Judge Simpson voices what everyone's thinking. How can one movement, grabbing, be permissible while another, slapping, be illegal? His words cut to the absurdity. What's the difference? That moment pulls the rug out from under the prosecutor's neat distinction. Judges rarely expose their reasoning mid-trial, so when Simpson does, it signals real doubt. He's not convinced that the prosecution's narrative holds up logically. But notice his precision. He's not siding with the defense yet. He's probing intent. Did Linda slap to stop the kicking, or did she slap to punish? That mental state is the fulcrum of the entire case.
The viewpoint of the people would be grabbing the leg to immobilize him to stop him from causing harm is in line with the other types of touching that happen today. It's in line with the types of touching that prevent Keaton from hurting himself or hurting others. Slapping his leg does not immobilize his leg, does not stop him from kicking.
Yes, it does.
Now, there was a characterization by defense counsel during his motion that defense put away. And not what that's not what was testified to. It was that it was a slap on the leg. It's not slapping the leg away.
You say potato, I say potato. I mean, what's the difference, Judge?
I'm a bit unclear as to what the people are arguing that the slap to the leg was in some way to place Keaton in fear or harm him in some way.
The prosecution escalates the rhetoric, suggesting the slap wasn't just reactive, it was meant to instill fear. That's a bold leap. Why? Because now they're arguing intent, not as control, but as intimidation. This matters under assault law. Even attempting to cause fear or harm can be enough for conviction. But here's the problem. No evidence shows injury, and even the state admits the slap wasn't forceful enough to harm. So the whole argument rests on perception. Was the action frightening or controlling? Prosecutors want the court to read into Linda's motives, but Judge Simpson keeps drilling down. Where do I get that from? He wants hard proof, not speculation, and that's where their case feels thin.
That it would be a violent, forceful, harmful, sort of touching for the purposes of the assault and battery statute.
Trying to figure out where I get that from, because and that's where I go to the intent. If her intent were to do that, then I might agree with the people. My concern is all of the testimony I have indicates that her intent was to stop him from kicking. That's different than if she is just attempting to try to cause some offensive touching to the individual. Unless I've got it wrong here, that there's some other strike to the child for some other purpose. Is there? Because
Evidence already to this point that the defendant was engaging in physical contact with Keaton to restrain him. The people's contention is that if she had wanted him to restrain him from kicking her, she didn't need to slap him on the leg. She could have simply gotten control of his leg and held on to it like she was holding on to his hands.
so he's on the floor as the testimony.
Maybe in the chair.
Well, no, hold it. Initially, he's on the floor.
Yes.
According to Victoria, the defendant picks him up by his arms and puts him in a chair. The people are not arguing that's an assault.
Correct.
The restraining, and I think they indicated also that she had part of her body and she's restraining him to the chair. That also the people are not arguing is an assault.
That's correct, Your Honor.
That then while she's restraining this individual in the fashion that she's restraining him, the testimony I have is that believes that Keaton was trying to kick her. So something is going on with his lower body at that point. That was, by the way, the testimony also is it was going on the floor when he was kicking. That her attempt to potentially stop that in that fashion would in people's mind then constitute an assault.
Yes, Your Honor.
Anything else from our side? Court's going to stand in very brief recess. I'll come back and give my decision on the motion. Back on the record in the case of the People versus Donald. The defendant's motion for a directed verdict, given the standard at this time, but also acknowledging as to whether or not an individual could find beyond a reasonable doubt, or a fact finder could find beyond a reasonable doubt that the defendant committed the offense of assault and battery, but also acknowledging that they have to take the evidence in the light most favorable to the non-moving party. The court is at this time going to deny the defendant's motion for a directed verdict at this time.
Big development. The judge denies the defense's motion for a directed verdict. Translation: Linda won't get an early dismissal. The case must proceed to full closing arguments. This is standard in criminal trials. Judges rarely cut cases short unless evidence is shockingly weak, but his wording matters. He says he must view evidence in the light most favorable to the prosecution. That's legal procedure. Even if he suspects the defense has a strong point, the rules force him to let the trial continue unless no reasonable fact finder could convict. Think of it as giving the state its fair shot. Strategically, this keeps the tension high. The defense had hoped for a knockout punch, case dismissed. Instead, they're back in the ring. This moment is where true courtroom drama peaks. Everyone now knows the verdict will hinge on Simpson's final interpretation of intent.
Your Honor, we're going to rest.
All right. Closing argument.
Your Honor, I'll be brief as I largely previewed my closing argument for the court from the people during the directed verdict motion, which is that in this case, the defendant responding out to assist this family in a mental health crisis did not go too far when she arrived. She didn't go too far when she tried to talk to the child. She didn't go too far when she tried to stop the child from hitting others and hitting herself, but that she did go too far when she slapped the 10-year-old child on the leg. We ask the court return a verdict of guilty for assault and battery. Thank you.
Thank you.
I will also be brief, Your Honor. And I thank Ms. Londy for narrowing the scope of the argument to that one point. It's something I didn't say to the court when we were arguing the motion. Ms. Londy said, Your Honor, it's the slapping. It would have been okay had she grabbed his leg to keep him from kicking her, but not to slap the leg away or slap the leg. She objected when I used the word slap the leg away. Your Honor, take it out of the context of CMH worker and a 10-year-old kid. Somebody tries to kick another individual. That individual is not going to sit there and say, gee, what's an appropriate response? Is it okay if I grab the leg, but not okay if I slap the leg? No, that you don't have that luxury, Judge. She did what she...
The defense closing hits hard with common sense. Forget technicalities, they say. Real people in real danger don't pause to analyze response options. You don't think, do I slap or grab? You act to protect yourself. This argument is powerful because it appeals to instinct, not statute. The defense wants Judge Simpson and viewers like you to imagine themselves in Linda's shoes. A kick is coming at your body. You react. Period. Notice the lawyer dismantling the prosecution's neat slap versus grab distinction, mocking it as unrealistic. That's effective rhetoric, because jurists and judges are human too. They know reflex isn't rational. By anchoring the argument in raw instinct, the defense reframes the slap as natural, not criminal.
Did in an attempt to keep from being kicked. And on that basis alone, she should be found not guilty.
Your Honor, just in rebuttal closing, context is everything.
Yes, it is.
Whoa, stop.
I was just agreeing.
Stop.
Oh, was that being?
Stop.
Oh, I was trying to.
Stop.
Sorry.
Go ahead, Ms. Londy.
Your context is everything. This is not a situation that happened down the street and someone tried to kick someone randomly. This is a situation where this child is having this mental health crisis, and this is the trained responder to come out. People contend it's not okay for him to be slapped by the worker that was supposed to be there to help him.
Court, looking at the entirety of this set of circumstances and listening very closely to the witnesses in terms of what was going on at that point, it is clear that Keaton is at an escalated point. That he does have, based upon the testimony, at times that he hits others, he's angry, throws things, and that at this particular point he wanted to kill himself. The two workers arrive scene, and as by the testimony, Keaton is on the floor. He's at one point, he's kicking, he has things in his hand that or some type of glass object or ball in his hands. The defendant in this case, this is from Victoria, indicates that she picked him up by his arms, put him in the chair, and that there was talk about how disrespectful she's being. So at the point in time, there is an attempt to de-escalate, is the best as the court could describe it, by putting him in a chair and restraining him in some fashion. That then at some point, and I think it's critical to realize that based upon the testimony, that when on the floor, he's described as he's just kicking. He's doing all kinds of things. She brings him up to the chair, restrains him. But what really one notices by the testimony is that what she's restraining at that moment, and what everybody testifies to, are his hands and his upper body. It is clear from at least the testimony and the way the court views it, that she doesn't have his lower body restrained. It then brings me to the testimony of Ms. Carroll, who indicates that she believes Keaton was trying to kick her. Say that again. She believes, because she's there looking at it, believes that Keaton was trying to kick her. Remember, the other witnesses are saying they can't see what Keaton's doing at that moment because of the way that the defendant is positioned. She then responds by slapping his leg just above the ankle bone. There's no testimony, slapped it, not that it would be necessary for an assault and battery, that in any way it caused an injury or hurt the child. But I think when one looks at the entire context of it, she had to have some intent to commit an assault. I don't believe that was what her intent was. Her intent was to stop him from kicking at that moment. Mind you, at least in this court's mind, based upon what the court hears, for the protection of everyone that's there. That's why she's restraining. That's why she's doing everything she does so that others aren't hurt by what is an unfortunate episode on Keaton's behalf. Not only legally, but also in good conscience, given the circumstances. This court could not, by any stretch of the imagination, find that the defendant intended to commit an assault and battery, or that the actions of the defendant in restraining Keaton, because it's all one act in terms of what she's doing. You can't parse it apart and say that slap to the leg is an assault as opposed to the actual restraining. She's trying to do a certain thing. Some may agree with it, some may not. But this court does not believe that she was trying to commit any type of an assault and battery upon Keaton at that moment. She was trying to keep everyone else safe, stop him from hurting anybody. More importantly, she was probably trying to stop him from hurting himself. And so for those reasons, the court would find that the people have not sustained their burden and would find that the defendant is not guilty of this offense. Defendant is discharged from any further obligation to this court.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor. Have a nice night.
Here it is, the verdict. Judge Simpson delivers a not guilty ruling. His reasoning is sharp. He cannot pass Linda's actions into separate legal boxes. The slap, he says, cannot be extracted from the broader act of restraint. Context rules. The judge makes clear her intent was to protect others and the child himself, not to harm. This case highlights the razor-thin line between intervention and assault, and Simpson ultimately refused to criminalize a split-second decision made in chaos. Broader implication. Cases like this test how courts balance professional responsibility with human instinct. Today, the balance tipped toward forgiveness, not punishment. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.